Hello aspirants, I welcome you all on the YouTube channel of ANALYST IAS. Our today's topic for focus of the day's discussion is the custodial death. It is a report which was basically placed in the Rajya Sabha. So we will see why and news, what is the data, reasons for custodial deaths, constitutional provisions against it. This part can be important for your prelims perspective. Then measures to prevent custodial death, way forward, today's prelims practice question and the mains practice question as well. So we'll start with the topic why and news. The Union Ministry of Home Affairs informed the Rajya Sabha about the custodial deaths. The Union Minister of State for Home Affairs shared the details of custodial deaths reported between 1st April 2017 and 31st March 2022 in all states and UTs of Indian subcontinent. Now here is the data. You can see that in the year 2021-22 there were maximum deaths in Maharashtra, then you can see Gujarat, then there is Bihar, then there is UP, and then there is Tamil Nadu. Here are other years as well. You can just pause and look towards it. Now the minister highlighted that a total of 146 deaths, cases of death in police custody were reported during 2017-18, then 136 in the next year, 112 in the next 100 in next year, 175 in 2021 and 22. The highest number of custodial deaths, 80, has been reported in Gujarat, followed by Maharashtra, then Uttar Pradesh, then Tamil Nadu, then Bihar. The minister said that the National Human Rights Commission has recommended monetary relief in 201 cases and disciplinary action in 1 case. What is the reason for custodial death? First of all, it's the non-accountability of the local police. In 2015, for instance, the police registered cases against fellow police officers in only 33 of the 97 custodial deaths. These deaths were labeled as suicide or natural deaths. There is a lack of transparency and poor communication with the family of the person. This generally happens when police arrest the culprit. The poor socio-economic background of the accused also helps police to use their torture mechanism as they are unaware of the law. This is one of the major drawbacks, that they are not aware of the law about their right to life and other laws as well. Now, India does not have an anti-torture legislation and is yet to criminalize custodial violence, while action against culpable officials remains very illusionary. Although India has signed the United Nations Convention Against the Torture in 1997, its ratification still remains. There is medical neglect or lack of medical attention. Then underlying health conditions or pre-existing medical conditions that are not adequately addressed or treated while in custody. This can also be a reason. Now, what are the constitutional provisions? Article 21 states that no person shall be deprived of his life or personal liberty except according to procedure established by law. Then Article 22 provides protection against arrest and detention in certain cases. And this, you have the right to know the grounds of your arrest. Then Article 20 ensures that the administration of the criminal justice system should not be so designed or implemented as to destroy the deeper and the moral values of the justice itself. Now, measures to prevent custodial deaths. Under the 7th schedule of the Indian Constitution, police and public order are state subjects. Remember this, that police and public order are state subjects. It is primarily the responsibility of the state government concerned to ensure the protection of the human rights, ensuring the presence of lawyer through contact with the nearest legal aid committee as soon as a person is taken into custody. The National Legal Services Authority should design processes that ensure lawyers are either stationed at police stations or on rotational basis or available on call. Now, a strict implementation of the DK Basu versus the state of West Bengal. This was a case, guidelines as well as NHRC guidelines by the state. If you want to know more about this case, just you can Google it. Behavioral change in the police force through training and awareness campaigns. Encouraging civil societies, human rights NGOs, NHRCs and SHRCs to play an active role in creating awareness and accountability of the police. Then implementation of Supreme Court's recent directive to publish FIRs online within 24 hours. And the person should be also brought down to the magistrate after his arrest within 24 hours. What is way forward? Amend the Evidence Act to place the ounces of proof on the police, to sensitize public servants to NHRC workshop and seminars for better understanding of the human rights of person in custody. Then police and public order are state subjects as per the 7th schedule of the Indian Constitution. Hence, it is primarily the responsibility of the state. Now we will come to our today's prelims practice question, that which institution has resolved to clear all pending cases against sitting and former legislatures in a time-bound manner. You have 4 options. Pause the video, try to answer. So basically, the answer to this question is D, and rest others have other functions as right, insolvency and bankruptcy board is for NPAs and others. Now we will come to our today's mains practice question, that National Human Rights Commission in India can be most effective when its tasks are adequately supported by other mechanisms that ensure the accountability of a government. In light of above observation, access the role of NHRC as an effective complement to judiciary and other institutions in promoting and protecting the human rights standards. This question came in the year 2040. This was all about today's topic. Stay tuned for the next one. Have a great day.